Good afternoon to you. We will now continue with the Constitution class. In the last class, we have seen the case of Sajjan Singh versus Union of India. Sajjan Singh versus Union of India. Similar on the lines of Shankari Prasad case, as you know, Supreme Court has decided that the Parliament has powers to amend the Constitution. In other words, Supreme Court interpreted that the term law included in Article 13 does not cover the constitutional amendment law which is made in exercise of the constituent power of Parliament. So, in other words, both Shankari Prasad case and the Sajjan Singh case, in both the cases, Supreme Court stood the same stand, took a same stand that the Parliament has powers to amend the Constitution and the law included in Article 13 does not include the constitutional amendment laws. This is the net result of both Shankari Prasad and Sajjan Singh case. Now comes what is very popularly known as Golaknath versus State of Punjab. Golaknath versus State of Punjab case of 1967. Remember, very important, 1967 Golaknath versus State of Punjab. You know, in pursuance of the abolition of Zamindari system and Land Reforms Act, Government of Punjab enacted a law. Government of Punjab enacted a law. What is that law? Punjab Security and Land Tenure Act of 1953. 1950, when the act was made? In 1953. What is the intention? To abolish the Zamindari system and land reforms. That is the purpose. This act was included in the 9th schedule under 17th Constitutional Amendment Act 1964. So, 1964 Constitutional Amendment Act, 17th Constitutional Amendment Act, under this act, the Punjab Act was included in Schedule 9. Schedule 9, because when you include a state law, it can be included in the 9th schedule only through Constitutional Amendment Act. So, 17th Constitutional Amendment Act added the Punjab Act of 1953 in the 9th schedule, extending judicial immunity to the act. So, this is what do you understand? That what is called Punjab Security Land Tenure Act of 1953 gave judicial immunity protection from judicial review by adding this in Schedule 9 under 17th Amendment Act 1964. So, this is the second part we should remember. Now, this Punjab Security and Land Tenure Act of 1953 affected a large number of zamindars. One such zamindar was Henry and William Golaknath. Henry and William Golaknath and their family. So that family, very richest family in Punjab, they have 500 acres of land in Punjab. In pursuance of the Punjab Act, the Punjab Security Land Tenure Act of 1953, Government of Punjab issued a notice to Henry and William Golaknath family saying that they are entitled only for 30 acres of land as against 500 acres of land. Therefore, they were asked to surrender 470 acres of land which was found surplus, for which they are not entitled. So, they were to surrender 470 acres of land by keeping only 30 acres of land with them. So, naturally, any person will get aggrieved. So, agreed by these orders, Henry and William Golaknath filed a writ petition before the Supreme Court under Article 32. Remember, when the Article 32 will be resorted to enforce fundamental right. So, under Article 32, both William Golaknath and Henry Golaknath, they filed a petition before the Supreme Court alleging violation of fundamental rights. Which are all the fundamental rights? 19(1)(f), that is the right to acquire, hold and dispose of property, and Article 19(1)(g), that is the right to practice any profession or trade or any business in any territory of India, and Article 31, that is right to property, and Article 14, that is right to equality. What are all the fundamental rights that have been allegedly violated by the decision of the Punjab government? These are all the fundamental rights which have been allegedly violated by the decision of the Punjab government. What are those? Article 19, Article 31, Article 14, and what is the article under which they have approached? Article 32. Remember, these articles very important. Now, the petitioners challenged the validity of First Amendment Act, which inserted Article 31B and Schedule 9. Number 1, Fourth Amendment Act, which amended Article 31, 31A and Article 305. In addition, 7 acts have been included under the Fourth Amendment Act in the 9th schedule that have also been challenged. They also challenged 17th Amendment Act 1953 in the 9th schedule. As you know, this schedule 9 provides judicial immunity to the acts added in the schedule from judicial review. This is the point you should remember. Now, the case was decided by one of the largest benches. At that time, this was the largest. What is that? 11 judges. 11 judges. The argument of the petitioner, this is 1967, remember. So, the argument of the petitioner was that the term law in Article 13 includes both the constitutional law and the ordinary law, and the Parliament has no powers to amend any part of the Constitution, especially fundamental rights. Kindly understand, very important point. Article 13 says that the state shall not make any law which takes away or abridges any of the rights conferred in Part 3 of the Constitution. If any law is made abridging or taking away any of the rights conferred in Part 3 of the Constitution, that law, to the extent of repugnancy, is null and void. So, the question was, the law included in Article 13 includes only ordinary law, or it includes both the constitutional amendment law and ordinary laws? That is the question. In Shankara Prasad and Sajjan Singh, Supreme Court said it talks only about ordinary law, it does not include Constitutional Amendment Act. Now, the question has come before the Supreme Court. In Golaknath case, the petitioners alleged that the term law not only includes ordinary law, it includes Constitutional Amendment law also. This is the question now before the Supreme Court. Now, the Supreme Court categorically said Parliament has no powers to amend the Constitution. Now, Parliament has no powers to amend the Constitution. It was a split decision. What do you mean by split decision? Split decision means out of 11 judges, 6 favored the one side and 5 is the minority decision. So, we have to go by the majority decision, that is the 6 judges have given one decision. On that basis, in Golaknath case, Supreme Court declared in their far-reaching judgment, remember it is a far-reaching judgment, that the Parliament has no powers to amend any part of the Constitution, especially the fundamental rights. The Supreme Court listed some reasons. What are the reasons? Kindly note down. Very important reason. It is useful for you in the main examination and also useful for preliminary. Kindly note down, understand one by one. You should remember this forever. Number 1, Article 368. Article 368 of the Constitution explains only the procedure, to amend the constitution and no powers have been given to the parliament. Supreme Court asked, see the article 368, this is talks only about the procedure. Where are the powers? You see the old constitution prior to 1971, it talks only about the procedure to amend the constitution. So Supreme Court asked, okay, 368 you are saying, but this gives you only the procedure. Where are the powers? Number one. Number two, the term law in Article 13 includes constitutional law also. Not only ordinary law, it includes constitutional law also. Therefore, the state cannot make any law for taking away or abridging any of the rights conferred in Part 3 of the Constitution, and if any law is made taking away or abridging any of the fundamental rights, that law to the extent of repugnancy is null and void. This is the second categorical statement of Supreme Court. Third, the Parliament has no mandate. Parliament has no mandate to amend the Constitution because the Parliament was elected only to rule the country, not for amending the Constitution. For amending the Constitution, you should go to Constituent Assembly. Because Constituent Assembly alone has the powers to amend the Constitution. You have been elected by the people only to rule. So confine yourself only to rule the country, not for amending the Constitution. Fourthly, very important. Fourthly, Parliament having been created by the Constitution under Article 79. Remember again, the Parliament having been created by the Constitution under Article 79, Parliament becomes the creature. Constitution becomes the creator. By any stretch of imagination, Parliament, which is only a creature, cannot meddle with the creator. So, it created a theory of creator-creature with regard to Constitution and Parliament respectively. This is the fourth argument. The fifth argument, the distinction between constituent power and legislative power laid down in Shankar Prasad case by Supreme Court is unfounded, baseless. Then, sixthly, fundamental rights are sacrosanct and transcendental. Even a unanimous vote of all members of Parliament, underline, even a unanimous vote of all members of Parliament would not be sufficient to undermine or weaken the Constitution. For example, I will tell you, tomorrow all the political parties, suppose in the Parliament or let us take a state assembly. In the state assembly, one particular party has come up with thumping majority. Out of 300, they secure 280. So all the 280 MLAs join together. They choose a criminal or they choose a minor who is less than 14 years of age as the chief minister. Will you allow? No, it is not. You have to abide with the Constitution. Howsoever you are tall, your Constitution is taller than you. So you have to abide by the Constitution provision. That is what the Supreme Court says. The fundamental rights are sacrosanct and transcendental. Even a unanimous vote of all the members of Parliament would not be sufficient to undermine or weaken the Constitution. If you are given the powers, tomorrow you will say, we will not follow republic. Day after tomorrow you will pass a law, we will not follow secularism. Next day you will pass a law saying this, we need not want democracy. So you will completely abrogate the entire Constitution. So, howsoever you are tall, howsoever you are powerful, howsoever you are in majority, you have a limitation. That limitation has been imposed by the Constitution, by the founding fathers of the Constitution. So, in nutshell, Supreme Court ruled that the Parliament has no powers to amend any part of the Constitution, more so the fundamental rights. So, this is the decision of the Supreme Court in Golaknath case. However, remember, till then 1967, 17 amendments have gone. 17 amendments have been made and put in the statute. Now, how can you put after 17 amendment, how can you say all the 17 amendments are wrong? It will create a chaos. It will create a confusion. So, Supreme Court for the first time employed the American doctrine. Whose doctrine this is? American doctrine of prospective overruling. Prospective. Prospective means future. Respect. Spectre means look into. Respect means I want to look you again. Retrospect means backwards. Prospective means forward. So prospective, that is doctrine of prospective overruling. The overruling is only from the prospective effect. Prospective overruling, based on which the decision would apply only to subsequent constitutional amendments. The result is, remember, the result, what is the result of this? Injustice to the petitioners. Normally, if a person wins the judgment should be in his favor, Golaknath favor. Whether he got the relief? No. The judgment gave the decision in favor of the stand taken by Golaknath. Whether Golaknath got any relief? No. The petitioners did not enjoy any relief. The result is injustice to the petitioners, since they got no relief, but only a consolation. What is the consolation? The posterity will enjoy the fruits of Golaknath case. The posterity will enjoy the fruits of the tree planted by them. The application of doctrine of Golaknath case seems prima facie unjustified, because the court applies a principle to the party but does not give any relief. Number one. Number two, according to House of Lords, the prospective overruling amounts to judicial usurpation of the legislative function, because they are putting a bar on the future legislative function. Secondly, Court of Appeal in Canada also held that the court should maintain independent, neutral and non-legislative role. Underline, non-legislative role. However, the fact remains, these are all our inference and interpretation, but the fact remains that according to the Supreme Court, in the Golaknath case, Supreme Court has declared that the Parliament has no powers whatsoever to amend any part of the Constitution, more so the fundamental rights which are sacrosanct and which have been kept at a transcendental position more than any other rights in the country. So, with this we will end the class. Tomorrow we will see the most important case of Kesavananda Bharati versus State of Kerala. Thank you.